en el encarcelamiento y la persecución penal de los cultivadores. Entonces, en este proceso lo que podemos ver en estas ambivalencias y multiplicidades del cannabis, lo que está atravesando también como tendencias fuertes son los procesos de mercantilización, digamos, cómo el cannabis se va transformando en un objeto a circular en un mercado legal, y cómo el cannabis incide en procesos de formación de Estado, en el sentido de que se forman agencias reguladoras, se van a formar regímenes de acceso a determinados derivados, sistemas de registro para los cultivadores, médicos y profesionales de la salud. Bueno, hasta acá llegué, gracias.
José Domingo Giovanni, from the Universidad Autónoma de Querétaro, and he will be speaking about a historical review of cannabis in Mexico as it relates to labor law. By the way, there's a mistake in the spelling of the name, right?
There's a mistake in the spelling.
There's a mistake.
This is your name.
No, that one.
Oh, okay, it's not Giovanni, right? Okay.
You guys might be able to.
All right, Jose.
Thank you. Bueno, pues buenas tardes a todos. Voy a presentar esta ponencia que es parte de unos avances de un proyecto de investigación de mayor alcance que estoy realizando en el Departamento de Estudios Interdisciplinares del Trabajo en la Universidad Autónoma de Querétaro, que se enfoca en la relación entre el consumo de drogas y el derecho laboral en México. Y en específico el día de hoy me centraré en el consumo de marihuana y lo trataré de abordar con una perspectiva histórica. La ponencia se titula A Historical Review of the Relationship Between Cannabis and Mexican Labor Law. In today's Mexico, it's not easy to explain the precise legal status of cannabis. As observed over the 3 days of this conference, we have frequently heard in various conversations dialogues questioning whether indeed marijuana is already legal in Mexico or not. This question results from the fact that for 2 years now, in the international press, it has been common to find new reports about a supposed national regulation of cannabis in Mexico. But these reports are often ambiguous, and there are a series of technical points, very specific legal issues, which make it difficult to understand precisely what is happening. To begin, I will take a few minutes to summarize the current state of Mexican cannabis legislation. Subsequently, in the second part of the discussion, we will delve into a more precise question. What are the spaces in which they intersect, and what are the points of tension between this new legal status of cannabis and the workplace? More specifically, what is the relationship between the emerging new legal status of cannabis and the federal labor law? In formulating an answer to these questions, it is essential to explore the historical background and, in particular, court rulings with which the Mexican government has addressed and grappled with the concept of intoxication arising from the use of substances within the workplace. Many of these rulings are still valid today. These court decisions, handed down over previous decades, are essential precedents to be considered when projecting the manner in which cannabis regulation will be harmonized with Mexican labor laws over the short and medium term. Okay. Then let's start by synthesizing the current legal status of cannabis in Mexico. In 2019, the Supreme Court ruled that the absolute prohibition of marijuana use is unconstitutional. This was a turning point in the contemporary history of cannabis in Mexico. According to the Supreme Court, every Mexican citizen has the right to consume marijuana, since prohibiting it will constitute a violation of the right to the free development of one's personality, which is considered to be a fundamental right. Furthermore, as part of this resolution, and this is a very important point, the Supreme Court required the legislative branch to draft a national law, a regulatory framework such that Mexican citizens who choose to use cannabis could do so in the unimpeded exercise of the right to free development of personality. In other words, the Supreme Court ordered legislators to establish national regulations similar to those of Canada or Uruguay. But this has not yet been accomplished, and the legislative process is currently at a standstill. Several months after the Supreme Court ruling, the Senate began the process of creating this regulatory framework. 17 bills were presented, discussed, and amended, and a comprehensive law was approved called the Federal Law for Cannabis Regulation. Up until that point in time, in 2020 and early 2021, it seemed that the legislative process will continue to move forward. However, this bill was approved only by the Senate, while its review and vote in the House of Representatives remained pending. There, in the House of Representatives, after several modifications were made to the bill, it received a favorable vote. But when the bill returned to the Senate, its place of origin, the modifications introduced by the representatives were poorly received, and the passage of the law came to a halt. More than a year has transpired, and neither the representatives nor the senators have agreed on whether or not to accept the modifications, and consequently, the bill has been stuck in a kind of legislative limbo. Thus, we can conclude this first point by stating that the regulation of cannabis use in Mexico is still far from becoming public policy. The widespread use of marijuana in Mexico is still not allowed. It remains unregulated, and its cultivation and marketing are still considered a federal crime. However, despite this legislative gridlock, the resolution of the Supreme Court in 2018 allowed any citizen of legal age the right to request permission from the health authorities to cultivate cannabis for personal consumption. However, in order to do this, one must go through a process that requires circumventing bureaucratic procedures. To date, there are only a few individuals who have been able to obtain permits to grow cannabis for personal use. However, and here we enter into the second part of this discussion, individuals with special permits to cultivate and consume cannabis find themselves in a gray area, first because there is no public policy that encompasses them, and second because other laws place them in a situation of legal vulnerability. One of these gray areas relates to labor law. Those who currently have permission to consume cannabis may face serious legal problems in the workplace. In other words, their boss or employer could terminate them with cause due to cannabis use. And not only for consumption in the workplace, but also for consumption on their days off. And furthermore, if at some point in the short, medium, or long term, the federal law for cannabis regulation is approved, this problem will no longer be exclusive to those who have individual permits for consumption, but will then become a potential problem for any citizen. So the question here will be, if in these cases, an employer suspected and accused a worker of consuming cannabis, why would this be a reason for dismissal with cause? That is, do workers not have rights and legal tools available to defend themselves with respect to such consumption? To answer this question, it is necessary to review some historical background. The federal labor law was adopted in 1931. In the original text, workers were prohibited, among other things, from going to the workplace while intoxicated or under the influence of any narcotic or mind-altering drug. Also, as of 1931, the criminal code lists cannabis as a narcotic. Additionally, in later sections in the chapter titled Termination of Employment Contract, it is clearly stated that the dismissal of a worker in a state of intoxication or under the influence of some narcotic or mind-altering drug exempts the employer from any liability. However, starting in 1931 and over subsequent decades, the application of this article was subject of interpretation by the courts. How and under what circumstances could the employer terminate an employee who used alcohol or drugs? Since 1931 and throughout the 20th and 21st centuries, these interpretations by the labor courts have been reviewed on dozens of occasions by the highest court in the land, the Supreme Court. In the archival research conducted, we found more than 100 such cases. This discussion is based on an analysis of these rulings, and by systematizing and analyzing them, we were able to identify two patterns. First, the resolutions discussed the reason for justifying intoxication in the workplace as grounds for dismissal. And second, there is a concern on the part of the authorities about how the employer must demonstrate and prove that the worker was, in fact, intoxicated in the workplace. As for the first point, the reason for which these dismissals are justified, in 1948, the Supreme Court issued a finding that has held firm to this day. It specifies the reasoning behind the prohibition of intoxication in the workplace as follows, quote, "In the performance of their services, an intoxicated worker can endanger their own life, as well as that of their colleagues, or the safety of the workshops in which they work." In addition, the court continued its argument as follows. Workers in a state of intoxication are not in a position to perform their services with the appropriate intensity and care. This criterion seems obvious, but it's important that it has been clearly affirmed by the court and that it remains in force, because in the future it may be taken up again in the case of individuals dismissed for the use of drugs, of other drugs, as in the case of cannabis. And the question in these cases would be, is the cannabis user really endangering their own life or that of their colleagues, or are they reducing their capacity and effectiveness while at work? In this regard, in 1949, when analyzing the case of an employee fired from a department store, the Supreme Court issued a finding which established the similarity for legal purposes between arriving to work while intoxicated and the act of becoming intoxicated while at the workplace. And it concludes with the consideration that both arriving intoxicated and becoming intoxicated at the workplace are grounds for dismissal. This consideration by the court will also be crucial when it comes to cannabis, because it will not be limited to the worker being required to have consumed cannabis while at work, since, according to this criterion, a worker arriving to the workplace under the influence of cannabis is also grounds for dismissal. Still, the problem here is that said effects, in the case of cannabis and according to contemporary scientific evidence, are very difficult to verify with technical precision, since the consumption of cannabis could have been in previous days, weeks, or months. And even so, a test could still result positive. And furthermore, this detection is complicated by the fact that any consumption carried out in previous hours, days, weeks, or months could have been for medicinal purposes, which is permitted by Mexican law. On this issue regarding proof of the worker's intoxication, in 1945, the Supreme Court declared that medical reports were no longer necessary, and that the statements of people who had witnessed the worker's intoxication were sufficient, even if they did not possess any medical knowledge. In this regard, the Supreme Court specified that, quote, "The ingestion of alcoholic beverages and the organic alteration they produce are likely to be perceived through the senses of any person, and that, therefore, there is no need to obtain any medical or technical opinions. This criterion will be repeated in the following years on 5 consecutive occasions and will become established jurisprudence. That is, it will have the value of a law applicable to the population in general. With this jurisprudence issued in 1963, the Supreme Court determined that intoxication caused by alcoholic beverages could be accredited by ordinary testimonies based on the following reasoning. Quote, "The simple state of intoxication in the workplace is manifested by the inflections of the voice and the difficulty in speaking, due to the loss of balance and due to the lack of prudence and moderation in expressions, which are behaviors and characteristics that all people, even the most ignorant, can appreciate at first sight." It was concluded then that testimonial evidence is suitable to prove the state of intoxication and medical expertise is not essential. This is because said state of intoxication falls under the simple appreciation of the senses. As noted earlier, the resolutions were reaffirmed on 5 consecutive occasions, and those compose solid jurisprudence is still enforced today. Therefore, due to the validity of this jurisprudence, it will apply not only to alcohol, but could also be relied upon by labor court judges who could use it as an analogous criterion with regard to other mind-altering substances. In the case of cannabis use, for example, the testimony of a witness will suffice, and therewith said worker could be dismissed with cause. Still, it is a controversial issue due to its lack of technical accuracy and its subjectivity. So, when in 1963 the jurisprudence was adopted stating that medical opinion is not considered to be an indispensable requirement, the Supreme Court argued that the state of alcohol intoxication is evident and known by the majority of the Mexican population, and that, therefore, anyone can testify to the fact. But this is a delicate point if, in an analogous way, it is a question of using this reasoning to determine the state of intoxication of a worker who is allegedly under the influence of some narcotic. In the specific case of cannabis, it could be controversial in regards to its effects being evident to a majority of the population. According to the National Survey on the Consumption of Drugs, Alcohol, and Tobacco, 8% of the Mexican population between 12 and 65 years has used marijuana at some point in their lives, equivalent to 7 million people. As for alcoholic beverages, 70% of the Mexican population between 12 and 65 years has consumed them, approximately 64 million people. Based on these percentages, the court's criteria regarding the familiarity of the Mexican population with the effects of alcoholic beverages could be understandable, but such is not the case with regard to cannabis. Additionally, regardless of the fact that 8% of the Mexican population has used marijuana at some point in their lives, there is no valid reason to view with certainty the criteria of those individuals testifying as witnesses, since they do not have the technical capacity to detect and certify that a person, a worker, was under the influence of cannabis in the workplace. Okay. In conclusion, since 1931, the labor courts on hundreds of occasions have interpreted and reiterated that if a worker arrives to their workspace under the influence of alcohol or some narcotic, or if a worker consumes alcohol or some narcotic while at the workplace, under such circumstances and provided such intoxication can be verified even through a simple witness, then it will be effectively grounds for dismissal with cause. As we have seen in this presentation, this is a problem that affects workers, placing them in a situation of vulnerability before the law and before the employer. However, we are of the opinion that it can be resolved by harmonizing the federal labor law with the bill drafted by the Senate, the one we discussed earlier, that is stuck in the legislative gridlock. In this regard, although still pending legislative approval, the latest draft of the federal law for cannabis regulation already contains an article establishing that workers under the effects specifically of THC will not be able to drive vehicles, handle or operate equipment or machinery that may cause danger. But as for other workers, those who are not considered as special profiles for operating equipment or complex machinery, in those cases, the law for cannabis regulation specifies that consumption within the workplace will simply be subject to a monetary fine. However, establishing a fine for the consumption of cannabis in non-special workspaces contradicts the federal labor law, since in the latter, it is specified that consumption in such workspaces is grounds for termination of the employment relationship and not a simple fine. And this is an issue that we have identified as being a point of tension, which must be resolved in the future design of a comprehensive public policy regarding cannabis. If these problems are not harmonized by the legislative branch, then we can predict that the question will reach the Supreme Court, where the constitutionality of these laws will have to be interpreted through the lens of new technical and scientific evidence, and a decision will be handed down which attempts to reconcile the interests of the employer and the rights of the worker. Thank you.
Yo, all speakers, we have a lot of time. We have about 30 minutes for questions and answers. So please raise your hand.
Prendido.
Oh, I'm sorry.
Bueno, una pregunta para